Senator Brandis.
Senator Humphries.
Thank you, Madam Acting Deputy President. There has been considerable misunderstanding, even ignorance of proper process exhibited by those who contributed to this debate from that side of the chamber. I want to touch on a number of those matters. First of all, it's important to remember that the Attorney General, not just of the Commonwealth but of any jurisdiction, holds a particular place within the legal system. And the Attorney General holds a place which is not akin to any other role played by any other minister in a government. The Attorney General is described as the first law officer of a jurisdiction and has special responsibilities, usually as an officer of the chief court of a jurisdiction, towards the good functioning of the court system of that particular jurisdiction. No doubt, Ms Roxon is a registered legal practitioner, an enrolled legal practitioner of the High Court of Australia, as indeed many other legal practitioners in this chamber would be, notwithstanding that they are now politicians. And as such, they have obligations towards the good functioning of the legal system, and particularly as Attorney General, Ms Roxon has responsibilities towards the functioning of that system. But in what she had to say on litigation involving the Commonwealth, she went far beyond and outside the role that she has as a protector of that system. The comments she's made about the litigation initiated by Mr Ashby were quite inappropriate given the circumstances of that litigation and her obligation towards the court system. She described his case as vexatious, an abusive process which had an, I quote, ulterior motive. She said the Commonwealth strongly believes that this process has been one which is really for an ulterior purpose, not for purposes of an ordinary workplace complaint. And of course, as Senator Brandis has pointed out, when other members of the government made even more injudicious remarks about this litigation, such as the remarks of Senator Carr that have been referred to, as a defender of the court, as chief officer responsible for defending the court within the parliament, Ms Roxon fell silent and refused to defend the proper processes and asked her colleagues to refrain from commenting on these matters. Now, putting it to one side for the moment, the fact that these are matters involving allegations of sexual harassment, and we've had a lot of lecturing from those opposite about the importance of respecting people's right to pursue matters of sexual harassment in appropriate circumstances. Putting that to one side, I want to put those comments by the Attorney General in contrast to what the obligations of the government, and particularly the Attorney General, are under the government's own guidelines for litigation. There are legal services directions which govern the way in which the Commonwealth acts as a party to litigation. And those obligations are quite clear. They indicate, for example, that if a matter is to be settled, a matter in which the Commonwealth is involved is to be settled, that in the case of major claims, that is claims above $25,000, that they're to be settled only if written advice is received from the Australian Government solicitor or other legal adviser external to the agency that the settlement is in accordance with legal principle and practice. Well, what is legal principle and practice? Well, it's set out in the same legal services directions. And I quote from Appendix C, Item 2. Monetary claims covered by this policy are to be settled in accordance with legal principle and practice, whatever the amount of the claim or proposed settlement. A settlement on the basis of legal principle and practice requires the existence of at least a meaningful prospect of liability being established. And it goes on to say, in particular, settlement is not to be effected merely because of the cost of defending what is clearly a spurious claim. End of quote. Now, how is that comment, how is that obligation on Ms Roxon as the Attorney General not to settle matters which are spurious in nature consistent with her claims made earlier in the litigation that the claim brought by Mr Ashby was vexatious, an abusive process, had an ulterior motive, and it was executed with the clear intent of publicising it before it was filed. You can't have it both ways. It can't be both a matter which is so flawed, so unworthy of consideration, that the government then proceeds to put $50,000 of taxpayers' money into ending the litigation against the Commonwealth. Under the legal services directions that govern the actions of the Commonwealth as a litigant, it was not open to Ms Roxon to settle this matter if it was indeed without merit. It clearly must have had merit. It must have had merit for the claim to be settled in that way. There is no other interpretation of what's been done consistent with the legal services directions. Now, if the government maintains otherwise, let them table the advice with respect to this matter. Why don't we see the advice? The matter's been settled. The matter's been settled. We don't need to worry about it interfering with litigation. Let's see what the advice actually has to say. And we have meetings of the estimates committees next week, Madam Acting Deputy President, where I'm sure that opportunity could be furnished by the government if it wished to do so. The fact is, this has been politicised from day one. This has been handled in a way most designed to defend this government's shaky hold on power by defending its special relationship with the Speaker of the House of Representatives, Mr Slipper, even to the point of allowing the judgment of individual members of the government to be clouded to the extent that a judge of the federal court had to say the other day that the behaviour of the Attorney General, the first law officer of the Commonwealth, quote, undermines public confidence in the courts. I repeat, undermines public confidence in the courts. Madam Acting Deputy President, this has been yet another indication of how this Attorney General has failed to understand her obligations towards the administration of justice in this country. She was quite prepared to make public prejudicial comment repeatedly when this litigation was at an early stage. But now, when she's been humiliatingly forced to acknowledge that a settlement of $50,000 has been made towards Mr Ashby on that part of the litigation that she was directly involved with, she now says that she doesn't wish to make further comment because the matter is before the courts. Well, of course, it was before the courts before. When she said it was vexatious and an abusive process and had an ulterior motive, it was before the courts then. But there was nothing that the Attorney General saw fit to do to prevent that kind of prejudicial comment going forward. And the comments of Senator Carr about this Ashby seems more rehearsed than a kabuki actor is highly prejudicial. It is highly inappropriate. Senator Carr went on to say, in Australia and around the world, there are a lot more serious cases of infringement of human rights than this. Now, that's indeed. How often does this government come into this place and the other place and lectured us about the importance of protecting people in workplaces from exposure to sexual harassment? How often has that been a theme hit by this government? Well, apparently a person's right to be free of sexual harassment in a workplace doesn't extend to people who try to enforce that right, who might at the same time be undermining the Labor government's hold on power. That's what it amounts to. The right is compromised if you happen to be an enemy of the state or an enemy of the Labor government, and that's extremely, extremely unfortunate. When the Attorney General entered the parliament in 1998, in her maiden speech, she said, and I quote, "We must not weaken the system," and I assume that she meant the legal system. "We must not weaken the system to the extent that we leave the powerful to run roughshod over others, or worse, resort to violence and intimidation to get their way. I am committed in the next 26 years to further strengthening our country's institutions." Well, this week, Madam Acting Deputy President, and last week she hasn't strengthened them, she's weakened them. She's weakened them. And that's the sort of thing that anyone would be held to account for, but particularly the Attorney General of Australia.